Thank you very much, Jim, and lovely to join you for the first time. And thank you so much for the invitation. I'll limit my few words to Hersh Lauterpacht. As a student at Cambridge University in the early 1980s, I had sat in a room that was called the Hersh Lauterpacht Room, and we really didn't know much about this fellow except that he was the father of our teacher, Ellie Lauterpacht, who was our lecturer in those first years of teaching international law. It was in the course of my studies, and then subsequently I came to learn his enormous contribution to the scholarship of international law. But I didn't really home in very greatly on his role and relationship to the concept of crimes against humanity. That only became known to me when I was researching the book that became East-West Street, that was published in 2016. When I went to Lviv, I was invited to give a lecture on the cases that I do on crimes against humanity and genocide before various international courts and tribunals. And in preparing that lecture in Lviv, I made the surprising discovery that the man who really put the concept of crimes against humanity into the Nuremberg Statute and international law in the summer of 1945, Hersh Lauterpacht, had been a student at the university that had invited me to Lviv, but the folks who invited me were not aware of that fact. Doug will say more about Raphael Lemkin, no doubt, in due course. Lauterpacht was born in a small town just outside Lviv called Zhulkiev. He studied at Lviv Law School. He moved to Vienna because of discrimination against Jews in Lvov, as it then was in Poland. And he studied under Hans Kelsen and then moved to London with his new wife in the mid-1920s. Initially went to the London School of Economics, and then in 1937 became Professor of International Law at Cambridge University. By then, his work had already, as a scholar and just beginning as a barrister, to address the place of individuals and corporations in the international legal order. And he had already by then reached the view that the individual is the ultimate unit of the international legal order. And this is very important to understand what came next. When the war came, he packed his family off to America, and he then followed, spending time at Harvard and other places. He was very close to Felix Frankfurter, and came to know Robert Jackson. And in 1941, he was retained as a consultant by the American Jewish Committee to write a book, which became really the first book on international human rights law, called a Bill of International Rights of Man, which articulates the idea that every human being, because they are a human being, has rights under international law. He had come to know Robert Jackson during his time in America. He returned to Britain with his family in 1944. And in 1945, and he had worked on the UN War Crimes Commission, and in 1945, as negotiations began for what would be the Nuremberg International Military Tribunal, he was consulted by Robert Jackson, this is July 1945, on the drafting of the statute of the Nuremberg Tribunal. He had, by then, literally just a month earlier, published through Columbia University Press an International Bill of the Rights of Man. And so his focus was very much on how the individual can be protected under international law. And I've always thought, my main thesis is that the catalyst for that was his experience living in Lviv from 1914, 1915, up until the time he left. Three different communities: Poles, Ruthenians, now called Ukrainians, and Jews, roughly in equal numbers, about a third each of the population. A lot of tension, occasional killing, plenty of discrimination. And the question he really turned his mind to was, how can international law protect the well-being of humans? And he focused on the protection of the individual. He'd done his work on human rights, published, as I said, in June 45. Jackson consults with him on the protection of civilians. in the period 1930-1945, and it is Lauterpacht who puts to him the idea that the statute and Article 6 of the Nuremberg Statute should have titles in them, and he proposes crimes against humanity. And that will be the first time that the concept of crimes humanity appears as a legal concept. It had previously been used or adverted to as a sort of policy concept, but never as a legal concept, essentially reflecting the notion that the widespread and systematic harm to human beings as individuals was a crime under international law. And that is essentially what crimes against humanity reflects. He got it into the Nuremberg Statute, and he subsequently argued it at Nuremberg and defended it subsequently. I'll close just by saying that Lauterpacht never met his contemporary, Raphael Lemkin. They may have been in the same room together in Cambridge in August 1945, but there's no evidence that they met or that they actually spoke to each other. He was aware of Lemkin's project of protecting human beings as groups, but was very dismissive of it at the time that it was being bandied around by Lemkin and talked about and written about, and remained for the rest of his life very skeptical about the concept of genocide. Lauterpacht's thesis was that the problem with the protection of groups is that it would replace the tyranny of the state with the tyranny of groups. Lemkin's response was that may well be, but the reality in the world, and we're seeing this, of course, today, is that individuals are targeted not because they have done something that merits targeting them, but because they happen to be a member of a group that is hated at a particular moment in time and place. And so Lemkin's thesis went, if you want to protect the individuals, you should protect the groups of which they are a member. So you've got two different theses emerging at the same moment in around 1944, 1945. And of course, there's been a struggle between them ever since. And my own work in East-West Street, for those of you who've read it, well, you will be aware that my sort of intellectual direction is very much with Lauterpacht, and that ought to be the focus. And I have, through my cases, come to be very concerned about the effect of the concept of genocide, not in the end as a protective mechanism, but as a mechanism which actually reinforces intergroup hatred. And we can say a little bit more about that later. But I have to say, East-West Street ends with an embrace of the ideas of Raphael Lemkin when I found myself standing at a mass grave in the small town of Żółkiew, where Lauterpacht's parents, where Lauterpacht was born, and where my great-grandmother was born, and standing before a mass grave in which 3,500 people were there in an unmarked grave, simply because they happened to be the member of the wrong group at the wrong time in the wrong place. So I completely recognize the complexities of these issues. And that is probably a moment to hand over to Doug to take up the running with the concept of genocide.
Well, thank you for that. That's this is a joy to follow up on this. I think East-West Street for me, as I was preparing the manuscript of my book, was wonderful. And I want to hit one common theme there, which I think is really smart, which is the Lauterpacht and Lemkin were offering two philosophically different notions of what international law should do at one level. And for me, what's curious about this is that, yes, they have this shared background. Yes, they have these common universities. Yes, they took all these same law professors at Lvov. And what's interesting to me is Lemkin starts off thinking that genocide will be a crime against humanity, and that the right to enjoy whatever subjective identities you have and hold should be an individual right. And he sees himself as, the inheritor of Lauterpacht's definition, and Lauterpacht is just, like this doesn't make sense. It doesn't hold philosophically. And for me, I think, Jim had asked us to speak about the reflections on what these two figures would think about international law today. And I would suggest that Lemkin's autobiographies that he's writing at the end of his life, would suggest that on the one hand, he would recognize a lot about the legal landscape. On the other hand, he didn't even recognize the concept of genocide that gets through the UN drafting process as his own concept, even though publicly he says that it is. And for me, the difference there is that Lemkin defined groups so broadly initially that he considered gamblers to be a social group, people with red hair to be a social group, trade unionists to be a social group. And he very much thought that the intentional act, especially by states, to destroy social groups, was represented in horrific harms to individuals' lives. So we have the four protected groups because of a diplomatic process where great powers literally sat in the negotiating room and wrote their own genocides out of the law. So it begins as Lemkin's using the words of colonization, defines genocide in 19, coins the word in 1941 before the final solution, which is significant, and very much looks at in the work Axis Rule in Occupied Europe calls genocide a colonial crime and destroying a two-phase colonial crime of destroying the identities of the oppressed and imposing the identities of the oppressor. Contrast that with the Genocide Convention today, and there's a world of difference. What happened between those two texts was a legal process at Nuremberg, and then really importantly, a political process in the United Nations. And that's the part where I think Lauterpacht at the end of the day was right, which is that Lemkin insisted that the law had to match the objective reality in the world, that people were targeted because of their groups, and so that should be outlawed. But Lauterpacht essentially saw that doing this was going to open the door to the politicization of international law around these identity cleavages and would make it very difficult to enforce. And I think I step back, and what was always so interesting to me about looking at Lemkin specifically was how disillusioned he was of international law by the end of his life. That line in his autobiography just stands out to me that the lights went off right in Paris, and all the diplomats shook their hands, and he said he was overcome with this sense that the Genocide Convention was now in the hands of statesmen who live in perpetual sin with history. That that hits a resonance there because it's John Foster Dulles who congratulates Lemkin officially, the last word to congratulate Lemkin on the Genocide Convention, and then turns around and works in the US Senate to prevent the US from ratifying the Genocide Convention, right? And it's the Soviets, right? Stalin with his red pencil, Vyshinsky with the blue pencil, line by line, editing the Genocide Convention to make sure that whatever happened, it could be used against the United States, but not the Soviets, right? You have Sweden that's very concerned about about a convention that would outlaw destruction of indigenous peoples. The French delegates want to make sure that the convention cannot apply to the colonies. And so for me, the moment there is that, I think to a certain degree, we're invested as people in the human rights community to constructing a narrative, which is that these instruments of international law were built by consensus in the post-war world, that this was a high watermark for humanity, and then by extension, then we look at the present order as a decline and sort of a collapse from that unified vision. And I would suggest that it never was very much consensus at all about what international law could be, and that from the very beginning, both Lauterpacht and Lemkin, in their very different ways, were concerned that great powers were going to pick and choose which things they cared about, which things they didn't, based on crude interests, and that they would stand by their allies above all evidence. And that to me is I think a moment that resonates now with when you look at international law. I think you see great powers picking and choosing, but then also just standing by their allies, defending their allies. Now, you come back, and I think if there's a moment of hope, it's with Lauterpacht, to be honest, not Lemkin, because Lemkin was a little shameless. He denounced African American civil rights leaders in the United States as communist saboteurs and un-American, because they embraced the concept of genocide. And he was worried that a white supremacist Senate, and he used that word, right? Like he used it, he didn't say white supremacist, but he was very clear that this was white, anti-Jewish, anti-black. And he was afraid that if the Genocide Convention was associated with black civil rights, the Senate wouldn't ratify it. So he publicly denounced black civil rights leaders for embracing this term. And he sets in motion a process that actually, in a lot of ways, created some huge hurdles, right? Facilitated huge hurdles in the US. And I think Lauterpacht was always more clear-sighted about the need for consistency and moral clarity. Um, and Lemkin was willing at times to play fast and loose and to publicly denounce. I mean, that to me is the biggest one. That these private writings that he says, where he's fully aware that Native American genocides are genocides and African American lynchings are genocide in his private writings, but publicly he denounces this. And I think there's a kind of moment there where, to me, Lauterpacht ends up being the one that offers a more pragmatic and clearer vision with that. So I relied on East West Street to hit the sort of like biography of it, and I editorialized a little too much. So I asked for Professor Sands, forgiveness, and Professor Finkel, your forgiveness. I like saying professor in this setting, right? You got books behind you, Jim. Makes me feel like you're a professor. So, all right.
I don't think that's ever going to happen. But anyway, Federica, it's over to you.
Great. Thank you, Jim, and to the APSG for having me back. It's truly a privilege to be able to comment on these two outstanding contributions to the body of scholarship that honors the life's work and legacy of both Hersh Lauterpacht and Raphael Lemkin. As you rightly say, two giants of international law and clearly foundational figures in international justice. I want to start by commenting both Philippe and Doug for their remarkable works, which I say without hesitation are, if in different ways, examples of true literary excellence. More specifically in the biographical subgenre, which they enrich without necessarily being pigeonholed by it. Frankly, I cannot compliment you both enough. As someone who's currently also immersed in a similar effort, as you heard, in relation to the biography of my late friend and mentor, Ben Farrange, I know intimately the numerous challenges that come with works of this nature, particularly when they're meant to shed light, as both your books do, not only on the life and contributions of the individual himself, including the, of course, human side of their story, but also to contextualize their work and legacy within broader and, of course, at times very much ongoing intellectual and policy debates. And you both do that masterfully. I also found rereading the two works side by side fascinating, precisely because of the differences that they present, but also the similarities that they evoke. The similarities, of course, as you heard, start with the, parallel, if you want, lives and journeys of the two individuals at the center of these two biographies, both born around the turn of the 20th century, hailing from the same disputed regions of Eastern Europe, from relatively well-assimilated middle-class Jewish communities who nonetheless became refugees due to the anti-Semitism and persecution to which they were subject, both attending the University of Lviv, where they took courses with the same professors, and eventually making their way to the United States. And given my current position this year as a British Academy Fellow with the Carnegie Endowment for International Peace, I would be remiss not to mention that both men also eventually developed ties to the Carnegie Endowment, Lauterpacht as a sponsor visiting professor in the US during the war, and Lemkin receiving support by the Carnegie Endowment at various points in his career, including for the publication of his landmark 1944 Axis Rules in Occupied Europe. And yet, of course, the individual intellectual journeys of the two individuals led them to pursue different, if related, in my view, complementary objectives through different approaches and clearly to different results. When it comes to Doug's work focusing on Lemkin's journey and intellectual contributions, it truly is hard to sing enough praises of how he so perfectly marries political and legal theory, philosophy, and history to contextualize not only the importance of Lemkin's life and work, but importantly, by looking at it through the prism of the social, political, and intellectual milieus within which they took shape. that achieves this by putting Lemkin thinking and ideas almost in conversation with those of other prominent intellectuals of his time who cross-pollinated Lemkin's own ideas. In addition, as I also tried to do with Ben French's biography, Doug goes to unparalleled depth in reconstructing the impact that Lemkin's studies, as well as his early formative experiences, including during his upbringing, had on him, how they influenced and shaped his work, to what degrees they shaped his commitment to international law as a vehicle to, or the vehicle rather, to eliminate the scourge of genocide, and of course the tools and strategies that he adopted in furthering this goal. From my perspective, it's also noteworthy that although Lemkin did not succeed, as Lauterpacht did with crimes against humanity, and including genocide as a separate crime under the Nuremberg, the statute of the Nuremberg tribunals, because of course the legal definition would only be agreed upon with the convention, is lobbying of American prosecutors in particular did ultimately pay off when both Telford Taylor and Ben French introduced genocide, the term genocide, as part of the prosecution's case in the trial of Otto Ollendorf and the Eisensgruppen. Ben in particular told me that he had deliberately chosen to use the word at trial as an acknowledgement of the validity of Lemkin's argument when he stated for the prosecution, so here the killing of defenseless civilians during a war may be a war crime, but the same killing are part of another crime, a graver one, if you will, genocide or a crime against humanity. And at the same time, Doug's work is equally remarkable, in my view, in not reducing Lemkin, his thinking, and what motivated it to a single group, identity, or experience, not even the Holocaust, while keeping a critical eye, of course, on the inevitable inconsistencies and flaws of both his intellectual arguments and of his trajectory as human being. As Doug narrates quite movingly, in my opinion, Lemkin's single-minded obsession, first with negotiating what in his mind was the correct definition of genocide for the purposes of the treaty, which of course he did amidst attempts by various governments to carve out language and contextual requirements that would have otherwise impugned their own conduct, made him turn on many of his own friends, including, most tragically, in my opinion, Vespasian Pella, who had helped shape his ideas and certainly shared his views. But he had become so paranoid at that point as to see enemies of that convention in every corner. And yet, when it came to his own attempts to convince the US government to ratify the treaty, again, he had become so fanatically obsessed with this purpose that by the 1950s, he had become what Doug defines as a hostage of politics, ultimately leading him to betray, as he writes, his universalist values and principles of tolerance and inclusion, just so that he could convince the establishment of the time to ratify the treaty. And this, in my view, is an important cautionary tale for all of us about the necessity to balance, compromises with necessary compromises with the personal and ethical values that each of us hold as individuals in this field. Philippe's work, on the other hand, follows a radically different, if equally praiseworthy approach in its personal first-hand take on telling both Lauterpacht's and Lemkin's stories, which he intertwines with the stories of other characters in his book, such as Hans Frank, whose estranged son Philippe sat down with to discuss his father's dark legacy as, one of Hitler's lawyers and Governor General of occupied Poland, who oversaw the slaughter of more than 1 million Jews and would eventually face justice in Nuremberg, as well as, perhaps more remarkably, in my opinion, Leon Buchholz, if I pronounced that correctly, Philippe, his maternal grandfather, who lived on that same east-west street of Lviv, and whose steps Philippe traces back from 2 old suitcases that his mother handed him, reconstructing his life in a manner that allows us all, I think, to relate intimately to just how personal the prosecution of European Jewry was, certainly to Philippe family, among the million of others whose lineage, hopes, and future were mercilessly and inhumanely tracked by Nazi barbarity. So this approach makes for a very moving, personal, detective-like story that reads as an enthralling novel, but one which nonetheless defies literary classification, as it uncovers past secrets while exploring the creation and development of world-changing ideas. I believe it was Maya Swart in her review of Philippe's book that said East West Street is a love song to lost ones. a requiem to another age, which I think it's a very poetic but certainly accurate way of describing what I think is a literally masterpiece. Now, as you heard, both Lemkin and Lauterpacht's chief, but clearly not sole contributions to international legal debates on how to define and understand the nature and essence of genocides and crimes against humanity as two new categories of crimes against civilians stemming from the atrocities of World War II did materialize in the context of 1940s debates, which trace back to the New Justice movement of the interwar period. And yet, the work of both men only experienced a renaissance in the late 90s amidst a revival of international justice and of the Nuremberg precedent, as you all know, following the atrocities in Rwanda and the former Yugoslavia. As I believe it was also the case with Ben Ferenc, both men played an instrumental role in challenging notions of international law and politics as usual, ushering a new understanding of that individuals and social movements are, in fact, key drivers of international relations. And so they, too, alongside states, should be considered both subjects of international law, but especially objects of its protection. And even though crimes against humanity and the crime of genocide are often portrayed as being rooted in different, even opposing notions of rights, that is, individual rights as the basis of crimes against humanity and the rights of groups as the basis of genocide, a distinction which Lauterpacht himself believed to be true. Doug's work shows how Lemkin, who is often portrayed as a group's rights thinker, in fact, believed that such distinction was inaccurate because, in his opinion, his articulation of the crime of genocide was also based on individual rights, which is the rights of individuals to practice their own beliefs and to express the subjectivity if as part of the traditions of way of lives that are representatives of certain communities. Ultimately, Doug writes how Lemkin's idea of genocide was an expression of cosmopolitan sensibilities, safeguarding a world in which individual rights could be freely expressed, including where these were seen and experienced as the basis of affinity to one or another group. And that is because Lemkin envisaged a world enriched by the interplay of individuals and groups, one where the encounter with the other is a source of enrichment rather than a threat to be feared and neutered. It is on this account that Lemkin considered genocide to be a subcategory of crimes against humanity because he believed they both share the same intellectual and philosophical roots. And it is for this reason that, and Doug writes in his book, Lauterpacht and Lemkin should be understood as working in tandem to advance a rights-based approach to international law, which I agree with. I would also add that their approach was so transformative that it spawned what I would call a human-centered revolution certainly in the broader field of international law, but that became foundational to all of the contemporary agendas that are concerned with prevention, protection, accountability, and the preservation and restoration of human dignity as cornerstones of government's duties and responsibilities. A vision that sadly today, as we all know, is being undermined, if not directly threatened, by revisionists who seek to close the door on human-centered notions of sovereignty in favor of Westphalian interpretations that both ascribe to states unrestrained authority on their domestic affairs and an absolute right of non-intervention therein. Concerningly, though not surprisingly, this is being championed by autocratic and authoritarian regimes around the world as part of a broader attempt to renegotiate not only their own role on the global stage, but the very rules and architecture on which the multilateral system is currently based, precisely because in their assessment, containing and refraining of horrific abuse of state power is an impediment to ascending to the rightful place in the world, a world where, if you will, Mike makes right again, and where civilians return to be nothing more than expendable pawns in their game of chess aimed to consolidate global power and hegemony. This, I think, is not only acceptable, but it directly offends the memory and contributions of those who, like Hersh, like Raphael, like Ben, and countless others in their and subsequent generations gave their all, including their lives at times, to ensure that the suffering that they endured because of their identity would never again be seen as legitimate or even inevitable. This, I think, tells us all that, we should feel an urgency to push back against such revisionism, whatever our capacity might be, because it is often the ideals and agency of individuals that move the needle when historical window of opportunities present themselves, as rare as they might seem. And in that sense, I guess, perseverance, purposeful agency, and strategic thinking should be considered the antidotes to the, I guess, all too common feeling of being hostages of politics, as it's often the case with values-driven individuals working in our field, and certainly have become the case for Lemkin at least. So I think that, in my opinion, this is possibly the biggest call for action that we should take away from both of these works, particularly at this critical juncture in world affairs in which revanchist ethno-nationalist movements, more so than political ideologies, risk appending the societal norms and legal protections that allow us all to at least aspire to live in freedom. So I think I'll leave it at that for now, but I'm very happy to continue the discussion because there is just so much more to say. Both of these works are so rich, and I am just so grateful to have had the huge privilege to comment on them and the opportunity to participate in this discussion.
Federica, thank you so much. Philippe, Doug, let me give you both an opportunity to either respond to one another or to respond to Federica.
Well, maybe I can pick up on a theme that's touched on in both of them, and it comes from a question we were discussing before we came on, namely, what would these two remarkable but very different characters think if they were to suddenly emerge from the darkness, open a front door, look out at the world, and see what was going on? And I think they wouldn't be surprised at all. I think they would both say, nothing changes. Plus ça change, plus c'est la même chose. I think Lauterpacht would probably say, my thesis was proved right, that what has happened is that the concept of genocide has been weaponized on all sides for particular purposes and has had the effect of reinforcing rather than protecting. I think he would look, for example, at what has happened, the most recent case filed at the International Court of Justice by South Africa against Israel, and say, this is what happens when you adopt rules without placing them in their broader context. I think it is important to remember when considering that case, and amazingly, the press has really not reported it, and people, I mean, I talk about this at conferences quite a lot, or public lectures quite a lot. People don't realize that there's no access to the International Court of Justice for war crimes. There's no access to the International Court of Justice for crimes against humanity. So if you see something going on that's particularly nasty and you want to do something about it, if you want to get to the International Court of Justice, you have to shoehorn your case into a genocide narrative. And exactly as Doug has said, there is an enormous gap between the way ordinary, smart, intelligent folks think of what genocide is, which is doing nasty things to people on a very large scale, with, on the other hand, what the legal text adopted in 1948 actually provides for, which is to set a very high threshold. I know, having argued many cases before the International Court of Justice, that it's very difficult to prove genocide. It's very difficult to prove that special intent to destroy a group in whole or in part. And what that means is there is a gap between public perceptions of what genocide were, exactly as Doug says. Lemkin set the bar much, much lower. For Lemkin, genocide was not a numbers game and was not about particular types of groups as opposed to others. It was really all groups. And the effect of the convention, coupled with a very strict interpretation by various international courts and tribunals, has been to make it almost impossible as a matter of law to prove genocide. And that gives rise to a very great frustration for people, and it puts international judges in an impossible situation. It's important to remember that in all of the cases that are brought before the International Court of Justice, on no occasion have the judges of the International Court of Justice found that a state is responsible for genocide. In the Serbia versus Croatia case, they found only that Belgrade was responsible for having failed to prevent others, paramilitary groups, to perpetrate genocide. And it's really only individuals so far who have been found responsible for genocide before the ICTY, the ICTR. And I think there's a very big issue here that people have not really teased out, namely, do we want a system of, if you like, interstate accountability, or is it better to focus on individual criminal liability and accountability? And I think that's an important debate to be had. And if we come back to the issue of Israel, Palestine, Gaza, it is fascinating. And again, it has not been picked up by the press, that as the International Court of Justice continues to struggle with their case brought by South Africa, the prosecutor at the International Criminal Court has issued indictments in relation to Hamas, in relation to two Israeli nationals, but it has been in relation to crimes against humanity and war crimes, not genocide. And so you have this curious situation now in The Hague of two international courts essentially focusing on largely the same or overlapping issues, but proceeding on different frameworks. And what I'm left with at the end of the day is a sort of sense of this is what happens when you do things in a great rush for the best of intentions and motives in 1945 without thinking through all of the consequences and the unintended consequences of what it is that you will do, because the legislative system, such as it was in 1945, well-intentioned, intending to protect the well-being of humans, has obviously thrown up now in practice a myriad of complexities and of difficulties. Now, the simple thing is to say, let's start again. Let's sort of wipe the slate clean. Let's reinvent the whole thing. That's not going to happen. We're stuck with these notions. We're stuck with a world in which, wrongly, in my view, many people put genocide at the top of the list of crimes. I don't draw any distinction between war crimes, crimes against humanity, and genocide in terms of their horror. But the reality is that if an American president says a war crime's taking place or a crime against humanity is taking place, no one pays the blindest bit of attention and it's not reported. It's only if the president says a genocide is taking place that it's on the front page of every single newspaper. And we need to ask ourselves why, and what is the social utility of that, and what are the consequences of that. And we need a more honest, I think, debate without criticizing the originators, who were remarkable people doing the best they could in the most appalling and difficult of circumstances, as to how do we want these or related concepts to be utilized to address human well-being. One final point. I don't think either of these two individuals will be surprised by what is going on now. And I'm not surprised. And maybe contrary to you, Jim, I mean, I'm horrified by the stories that take place. I'm horrified by what is going on in Ukraine, in Gaza. I'm horrified what happened on October the 7th. I'm horrified about what's happening right now and is completely unreported in Sudan. But am I surprised? No, because this has gone on, as Lemkin made clear, since time immemorial. And what I always come back to is a conversation I had as a young academic in the 1980s, when I was a research fellow at St. Catherine's College, Cambridge. And one of my colleagues was a wonderful professor of English legal history, Sir John Baker. And he'd sort of invite me in for lunch and say, what are you working on, Philippe? And I'd say, oh, I'm working on X or Y or Z. And he'd sort of stroke his little beard and he'd say, ah, yes, we had a problem like that in English law in 1472, and it took 275 years to sort it out. And that's where we are. We're in 1472. This is a new system. We're testing it out. We're teasing it out. I don't believe the system has fallen apart. Quite the contrary. I think it's absolutely fascinating that as the political processes collapse, there is a turn to law, and there is a turn to the judges, and there is a turn to these instruments, which are in the news more today than they have ever been. And that tells us something, perhaps not so positive, but nevertheless it tells us something. So I think there are multiple levels of complexity in how we think about these issues and then how we address them.
Doug?
Well, I love the idea that the to actually think positively about the current situation that we're in when all the incentives around us tell us that we should be quite pessimistic. I think that's, I think that's a really nice frame. So thank you for injecting that. Federica, I want to pass the compliments back to you, and say that I'm going to throw something in the chat here to everyone. So this is your recent article that I hope I got the right link there. That would be embarrassing. But anyway, your recent article on great power perpetrators. And I think that, there's something that I like from this article that I was thinking about as I was talking today, which is that, this goes back to what Philippe was saying about, that the dilemmas that crimes against humanity and genocide are nothing new. I think to a certain extent, that Lemkin's insight, which I think was really smart and really good, and he's so far ahead of his time that his contemporaries cannot understand him, was to take colonization and imperialism and link them, and to say that, look what this does to human beings, right? It categorizes human beings by arbitrary categories into citizen and non-citizen, human and non-human, and it sets in motion this process of targeting them in order to change the way they live for particular purposes. So he's quite comfortable talking about committing genocide against people because you want to turn them into enslaved peoples to pick cotton. And also he turned around and said, that's what the Soviets are doing with the new Soviet man, right? You're trying to, and so there was a sense there that what he I think when he's at the UN, he's negotiating. I think it's important that countries that are small countries and former colonies can outvote the great powers, which is how you begin that process of the Genocide Convention getting into place. But then you step back and you realize that in no universe was France going to ever want this convention to be a crime against colonization. So there's a kind of dynamic set in place that I think would be absolutely familiar to Lemkin. And I just, Philippe, I just love the idea of saying that, maybe actually we're in a point of progress right now, where instead of, we're at a point where you can write, Federica, an article about great power perpetrators, and people sitting in a room, many of us who work for the United States, shouldn't say us, I can say you at this point. Many of you work for the US government, you work in positions and institutions. I don't think in 1943 you would have had that moment of an open conversation about the possibility of great power perpetrators. And that,
yeah, I just want to come in on that, Doug, just to,
okay, yeah, come in.
to share just an anecdote that I think completely illustrates your point. In November 2019, I was in DC at George Washington University doing a panel with Tom Bergenthal, who, of course, you will have known very well, remarkable person. Tom Bergenthal, as many of you will know, was the American judge at the International Court of Justice, but 60 or 70 years earlier, he had been an inmate at Auschwitz, where he was under the care of Joseph Mengele. And I was about to go off to the International Court of Justice to do the provisional measures application on a genocide case brought by the Gambia against Myanmar. And Tom said to me, can you imagine, Philippe, if in 1944, when I was at Auschwitz, or 1943, when I was at Auschwitz, there had been a piece of paper called a convention, and there had been a faraway country which decided it wanted to act on the convention. And there was an international court. And that faraway country had gone to an international court and said, hey, international court, you can't treat people. Germans can't treat people like this in places like Auschwitz. He said, if nothing else, even if it hadn't stopped, it would have given us hope. And after the provisional measures application order by the International Court of Justice, a little later in January 2020, there was a photograph, you will remember it, of hundreds of Rohingya, members of the Rohingya community standing in Cox's Bazar, a refugee camp in Bangladesh, holding up pieces of paper which simply said, thank you, Gambia. And I think that is the difference between then and now. Sure, today is terrible. International law has not protected people on October the 7th in Gaza, in Sudan, in Ukraine, and in a myriad of other places. But it is at least now possible to make arguments and to go to international courts. I'm so sorry to interrupt, but your point is so powerful and so significant. I just wanted to underscore it.
I'm gonna come back and underscore it one more time. And this is something that I think Lemkin got right and Lauterpacht got wrong. Lemkin doesn't say a damn thing about a fair trial. He couldn't care less. He couldn't care less about fair process. He couldn't care less about due process or rights of defendants or anything. He believed that the purpose of international law was on par with poetry, right? And music and movements. And this will drive an international lawyer nuts, right? Because his whole point was international law was a vector of pedagogy. It was a point of teaching people morality, right? And so in that sense, you can say that maybe one of the things that Lemkin got right was that international law sets in motion these norms that become global norms. And you get to a point where today you can have these two countries that, anyway, I don't want to repeat it, but I want to say that this is a fantastic illustration that you're giving. All right, I'm going to stop talking because I'm going to lose my thread pretty quickly.
Federica, any thoughts?
Yes, of course. I mean, so many. So first of all, I want to thank you, Doug, for sharing the article and for sort of linking that argument about great power perpetrators to the discussion that we're having. I think the last point you made in particular about how international law, with all its flaws, does have, a normative and pedagogical role in societies is very important and really ties in with that argument I'm making, which is the power of norms, what I call productive power in the article. It's extremely important today, and it's very much a battleground for competition among great powers, and where we see those that are pushing those sort of revisionist views succeed is not necessarily because other countries around the world buy into the cogency of that argument necessarily, but it's because they've become, in a sense, discouraged by what they see, disingenuity on part of the other camp, if you like, the champions the opposing normative view. So I think that this should lead us all to believe, and again, it ties back to the point that Philippe was making about genocide, about the risks of, politicization of legal norms and principles and how we implement them, and the approach that we take in furthering those objectives. We need to really have a big picture, long-term view on the, sort of implications that this is going to have, both in terms of where it serves our purposes, but also the potential negative externalities that it might have. Because what we're seeing today is that, when it comes to the legitimacy of the normative champions of, human rights and global accountability, that's very much being questioned, and that is on account of what the rest of the world sees as Western double standards. And I'll share it in the chat, but I actually thought it was very interesting. The Munich Security Conference, of all places, where you absolutely would not expect this conversation to be happening, right? Published a policy brief very recently, which I thought was just brilliant. They call it standard deviation, in which they essentially survey populations, and I think it's like the 8 most populous countries outside of the Uyghur region, about their perceptions of sort of double standards around the world. And it's fascinating to me to see how, sort of the United States still comes up on top with respect to some of its adversaries, certainly China and Russia when it comes to, specific questions that are being asked as part of this survey. But it is, I think that the data that they amass and the analysis that they bring to bear in, discussing the implications of the data really underscores the need to, take a hard look at the way in which we as champions of certain norms go about their implementation and what the implications are around the world of that.